In today's videos, we are going to discuss about the penalties that the Indian DPDP Act puts in on both the data principals as well as on the data processors or the organizations who process personal data. And I am bifurcating them because it could mean different as well, just to ensure that they are compliant with the DPDP Act. Welcome to my YouTube channel where you daily see new content on data privacy, and as I said, we are going to quickly touch base on the penalties that the Indian DPDP Act has put in. First of all, let's talk about the non-compliance of data principals. We know data principals are the people whose personal information is being processed. We have a lot of content on the rights and duties assigned to data principals. However, if data principals are providing wrong information, or if they are not handling their own duties properly, they are breaching with the duties laid down by the Indian DPDP Act for a data principal, then the court, the Data Protection Board, can put a fine of around 10,000 rupees on such data principal where he has not fulfilled his own duties properly. That's about the principals. Now about the processors. Now processors here could be just a processing company, or it could be the entire organization who has collected the information, and fiduciary and processor and consent manager are a part of the organization, right? So the ownership of penalties and compliance is to the organization who has collected personal data and is processing personal data. And there are three criteria that the Indian DPDP Act has put in order to check that they are compliant with their information. First of all, it's the data security violation. How do they ensure that they keep data secure? If they fail to implement security measures, for example, if they are not able to follow the technical security aspects of confidentiality, integrity and availability, then they can be fined if in case there is a breach, right? So if there is a breach, it has been assessed and it has been found out that the basic security measures of keeping the data confidential, avoiding unauthorized access, have not been met. The data is accessible to any person who is not even concerned with the data. The data has not been properly encrypted, so someone could hack into the system and capture the data, or it has not even been properly backed up. So if the primary data is lost, there is no way how it can be recovered. Then in this kind of a violation, then there is a security violation and a fine of up to 250 crore Indian rupees to the organization handling the personal data. In case such a breach happens and the organization does not inform the data principals about this breach, as well as it does not inform the Data Protection Board about this breach, then there could be a hefty penalty of up to rupees 200 crores, right? So if in case there is a violation because of security issue, then the penalty could go up to 250 crores. If in case even the breach or violation has not been reported and has been tracked by someone finding a violation or a misuse of their personal data and tracing it back, investigating it back to a breach in an organization, then that organization will be fined to up to around 200 crores. If you are processing children's data and you are not able to cater to the norms of processing children's data, one is you need to have the guardian's consent for processing the children's data. Anyone less than 18 years, you need the guardian's consent. And the second thing is that you are not using the children's data for a direct marketing or direct advertising to the children, right? If that is violated, then you can also be penalized for up to around 200 crore rupees. So these are the kind of penalties you have. Non-compliance is a very heavy cost. First big cost is penalty, the financial one. That is not only the cost that you bear if you are found violating any of these norms, and if a data breach happens, there is a cost of mitigation that you might have to put in, because the data principal might demand anything, right? So while you are answering to the Data Protection Board, you might have to separately answer to the data principals, which cannot be defined by any boards. You would have to spend a lot of money on the legal procedures, the cost of the lawyers, the time that you need to spend in documentation, the time you need to spend in representing yourself in the court. So all that is an indirect cost which does not even have a direct number attached to it. And then the reputation of the brand and the trust that the customer had on you and allowed you to process their personal information is another very, very important thing that you might lose in case there is a violation of personal information. Apart from all that, at the end of it, you need to make sure you don't repeat your mistake. So you will have to then apply the security measures to the best of it. So there is a cost of rebuilding the entire set of security measures. So these are some of the very important things that are there that you need to take care of when you have when you get into a violation. So you need to protect yourself from a breach so that you save the cost not only of the penalties the Indian DPDP Act or the Data Protection Board will put on to, but also the cost of the legal recourse as well as rebuilding your reputation, your customer trust and yours. That's about the cost of non-compliance in the Indian DPDP Act. I hope you like the content of the video. Please press the bell and the like icon. Subscribe to my YouTube channel and share your feedback in the comment section. Thank you.